Hello friends, Patrick McFarland here of the Liberty Weekly podcast, coming at you with another episode. This one is episode 202. Show notes may be found at libertyweekly.net/202. And this is going to be kind of a legal episode of the podcast. I haven't done one of these in, I think, quite some time. However, I am a practicing attorney. If you are a new listener to the show, you might not know that. And I think I mentioned to the audience that I started my own law practice in early December, and I've been going strong. I have taken some COVID litigation cases, some issues revolving COVID-19. I've become involved with some other ones, and so it's led me to the point where I've actually been doing some analysis of federal court opinions regarding masking children in public schools. And I thought that I would try to bring you some of the analysis that we're getting in the federal courts. And this is kind of, I did an episode with Kyle Ancelone taking apart the OSHA mandate decision. Maybe I'll put a link to that in the show notes page, because that was an episode of Kyle's show, Conflicts of Interest. And forgot to mention, I'm also a part of the Libertarian Institute, where Liberty Weekly is a featured podcast alongside other fine podcasts, and Kyle runs Conflicts of Interest, and alongside also my buddy Keith Knight with Don't Tread on Anyone, and Tommy Salmons with Year Zero, and of course the great Scott Horton, who has the Scott Horton Show on the Institute, as well as a great team of writers over there. And I almost forgot Connor Freeman, who's the co-host of Conflicts of Interest. You saw Kyle and Connor on the last episode, which I hope you enjoyed. We got a lot of positive feedback from that one. And a lot of people were really told Kyle and Connor that they really liked the pause and play format, where you can really see how Kyle and Connor and myself stack up to talking heads that you will see. And you get some of that direct commentary where you can see some of, at least the things that Tim Pool and Luke Rudkowski say in real time get debunked. And of course, when we do things like that, there's always, there's a bit of pushback on it, which I do appreciate, but it seems like a lot of people were really just waiting for people in the libertarian movement to call out Tim Pool on his hawkishness. And I've done a bit of that on the podcast, but I think for some reason last week's episode really kind of hit a chord with people. And I think that was really, really cool. So I think we might continue to do those pause and plays with Kyle and Connor, and maybe kind of tackle some of the other China hawks out there, like Jack Pacific. And I'm just trying to think of all the people that Tim Pool has had on the show, maybe China Uncensored, some of those other people that are really hawkish, whose names just really aren't coming to me right now. So, like I said, we're going to be tackling a federal court opinion here on this episode, and I'll just put it on the screen. There's going to be a lot of kind of reading the opinion, and then I'll kind of explain through reading the opinion kind of how this structure all works. And keep in mind, I don't practice in federal court. These constitutional issues are not always things that I'm dealing with on a daily basis. So, but I can, like, I speak the language, and I have been studying this for some possible potential upcoming litigation. So you can get a glimpse. Doe Franklin Square Union Free School District is the case for those of you who are just listening to the audio version. I have the opinion pulled up here in front of me. This is the United States District Court for the Eastern District of New York. So this is a New York case. And this is the district court level, the district court decision. So in state courts, the circuit court, at least in Wisconsin, the trial court level is called the circuit court. And in federal court, the district court is the lowest level of court that there is. Then you hear about the appellate courts, and you hear about the different districts. And then on top of the federal appeals courts is the Supreme Court. So you have, this is the case, the heading Doe is because there's several plaintiffs who are minors and they don't wish to be identified. And they're suing on behalf, you can see the conclusions here. This is LexisNexis comes out with these. It consolidates if you're an attorney, you have a reporter service that you usually subscribe to, and the reporter service is what consolidates all the opinions, and a service like LexisNexis will compile all of it together. And actually they have these head notes here that it gives you like the basics. It's like cliff notes for attorneys, but you go through and here's the case summary. So 10,000 foot view, this is what the court held. The court ruled this, that the plaintiff parents were not entitled to a preliminary injunction with respect to the school district's mask mandate based on her alleged constitutional violations, including her allegation that it violated the due process clause of the 14th Amendment, because under a rational basis review, the challenge was not viable. And the second holding was that the mask mandate did not impinge upon any fundamental right, and therefore neither strict nor intermediate scrutiny was the applicable standard. And the third holding was that an injunction was not warranted because where good faith arguments could be made on both sides of issues raised by the pandemic, it was up to local governments and not the courts to balance the competing public health and business interests. The fourth holding and final holding was that injunctive relief on state claims was withheld because the parties were pursuing settlement with respect to the child's potential medical exemption. So I'm thinking of a different case. I said before that Doe was several kids, but it's just one kid. I'm thinking of a Michigan case I've looked at too. So I know that for a lot of people in the audience who aren't trained attorneys, those holdings were a bunch of mumbo jumbo, but I'm going to go through and try and explain it in layman's terms here. But in regards to the first holding, the plaintiff parent was not entitled to a preliminary injunction. So a preliminary injunction is something that when you go into a lawsuit and when the thing that's about to be imposed, when it has irreparable harm, if it were to go into place, then you would seek a preliminary injunction, and that injunction would stop whatever you're suing from going into place while the lawsuit is litigated. So I talked about this on Kyle Anzalone, Kyle's show Conflicts of Interest, in regard to the OSHA mandate, because people were suing the OSHA mandate, and the Supreme Court actually heard the preliminary injunction issue, is that while this lawsuit is proceeding, we want to put a hold on the enforcement of the OSHA mandate so that it doesn't go into place. Because if it did go into place, a bunch of people would have to fire their workers, and there would be irreparable damage to people's rights and to the economy, things like that. So that's why you would seek a preliminary injunction. So it's it's like happens very early in the lawsuit. But one thing that the courts look at when you're seeking a preliminary injunction is whether or not the person who's suing is likely to succeed on the merits of the claim. So they actually do look at the things that are at play. And one of the reasons why OSHA stopped their mandate was that the Supreme Court ruled that it was probably unconstitutional. And so from that point forward, OSHA's like, well, I mean, they got to decide whether they want to pursue it further. If the court already kind of says, well, it's probably not constitutional, maybe we just want to give up at this point. So now the due process clause in the 14th Amendment, a lot of people don't know this, and I think I covered this in early episodes of the show, but the Bill of Rights actually was never meant to apply to the states. The Bill of Rights was only meant to apply to the federal government. And admittedly, this is something I did not know when I started law school, is that the Bill of Rights to the federal Constitution was not meant to apply to the states. And it's only until the 14th Amendment is passed during Reconstruction that the federal courts started to rule one at a time, issue by issue. The federal courts started to rule that the federal Bill of Rights applied to the states. And there's no entire ruling saying that the entire Bill of Rights applies to the states. In fact, there's a few issues, a few liberties under the federal Constitution that have not been ruled to apply to the states, but the vast majority of these issues have been ruled. So the federal Constitution preempts state laws and says that the state constitutions have to at least minimally protect liberties under the Constitution. Now, the state constitutions can go further than the federal Constitution, but the federal Constitution is the minimum. that the states have to abide by. And as it kind of comes, there's this libertarian argument, right? There's this libertarian argument that the federal constitution preempting state constitutions is actually a gigantic overreach in federal power. And even if the federal constitution was to come in, let's say that a state government, and this actually happened, let's say that Alabama was depriving due process rights of African-American individuals. This actually happened. And there was a lawsuit that went to the federal courts, and it was ruled that the federal government could come in and force Alabama to honor the federal due process clause. And so even though that was a ruling that supports freedom, the libertarian argument would say that the federal government has no business going into Alabama and changing and dictating. Really, it's a act of tyranny from the federal government to dictate to the states that they have to abide by a minimum level of freedom. And this is something that Tom Woods talks about all the time, and something I tried to, because people yell at libertarians all the time for this. Tom Woods tackles it a lot and says basically, well, what happens when the federal government has a constitutional ruling that obliterates freedom, right? If the federal government is not if the federal government doesn't trample and hold the Bill of Rights over every single state, well, then each state can decide, and maybe a few of those states will have a very libertarian policy. But if the federal government makes a ruling, then the entire country's screwed, i.e. mask mandates. If there were a mask mandate case that was to go to the Supreme Court and the Supreme Court ruled that they were constitutional, then the entire country is subjected to it. Whereas, yeah, some states might violate people's rights that way, but if the states are left to decide, some of those states might be very libertarian on this issue. So this is going to be a long episode, man, because there's a lot of pages to this, but there's a lot of background that people need to understand when you're going through this, and I hope I can provide some of that. So the courts they apply the Bill of Rights through the window of the 14th Amendment. And there's a lot more issues that I've talked about a lot. I've covered extensively on the show about the problem that I see with judicial review is this idea that the ultimate expression of constitutionality is the Supreme Court, or that even the Constitution is the supremacy clause, right? Brian McClanahan talks about this in his book, and I believe Tom Woods does too. But in law school, you'll learn that the federal Constitution is supreme over all the states' constitutions because it says that the federal Constitution, there's the supremacy clause. I don't have it memorized verbatim. Oh, but what it says is that all laws made in accordance with the federal Constitution is the supreme law of the land. It doesn't say the Constitution is the supreme law of the land. It says all laws made in accordance that abide by the Constitution is the law of the land. And then it just is a matter of, what laws are made in accordance with the Constitution becomes the issue. But the Supremacy Clause doesn't say that the federal Constitution is the supreme law of the land, insofar as it says that laws made in accordance with it are. And in Marbury versus Madison, it seemed like there's some nuance to this, and I think libertyweekly.net/LL3, I think, is my episode where I talk about this explicitly. This was a long time ago. Yeah, the truth about judicial review. So if you go to libertyweekly.net/LL3, you'll go to my episode where I talk about this at length. But William J. Watkins Jr. went on Tom Woods' show years ago in 2017 talking about his book, or his law review article, rather, where I think he went to Duke Law, or the article was written in Duke Law, where they talk about, and he argues that judicial review, about the clear case doctrine, saying that a federal court should only declare law unconstitutional if it's if it's clearly unconstitutional. If the law is not clearly, if it could go either way, or if there's even like 20% of doubt on either side, whether it's constitutional or not, the court should kick it back to the legislature. And this was the understanding in all the state courts before Marbury versus Madison. So the state Supreme Courts actually found it an impeachable offense for a judge to declare a law unconstitutional if it was close, if the decision was close, because that was seen as transcending separation of powers, and that the courts would do the job of the legislature. And I know I'm throwing a lot at you, but these are topics that I've covered. This was my bread and butter when I started the show, when I was in law school. But so if we go back, and they're saying that what the Supreme Court has done is that the Supreme Court has, starting with Marbury versus Madison, took it upon themselves really to say that we are the ultimate bearers of constitutionality. So what they've done, and this is how they can take the Bill of Rights and take something that says Congress shall make no law abridging the freedom of religion or of the people peaceably to assemble. You and me and everyone with common sense, I've talked about this in my speeches, my COVID speeches, everyone having common sense and knowing the English language can look at the Constitution and can clearly see that it says Congress shall make no law abridging the freedom of people peaceably to assemble. You and I know, right, that while the text of the law is very clear, that should mean that the government shouldn't be able to prohibit people from going out to work, even if there's a crisis, right? I mean, that it's black and white in the Constitution. But judicial review, the courts have taken that over the years and have declared basically, and we'll get into that, have declared basically that, well, even all the liberties expressed in the federal Constitution, every liberty has it's circumscribed. There's limits to every person's liberty. I mean, we can't just have everyone having these absolute rights, right? So they created out of thin air, sound familiar? And it was in the same era as the Federal Reserve was started. They created out of thin air, mostly during the progressive era, this idea of rational basis review, the levels of review, the strict scrutiny, rational basis review, intermediate scrutiny, rational basis with a bite. These are all review, like different standards of review that the Supreme Court uses to determine if a law violates the Bill of Rights, essentially, in layman's terms. So they're saying here in the second holding, the mask mandate did not impinge upon any fundamental right, and therefore neither strict nor intermediate scrutiny was the applicable standard. So the Supreme Court made this up, and they said that if a right is fundamental, the strict scrutiny applies, where the law has to be narrowly tailored and it has to fit a compelling governmental interest. And that's a pretty high standard to meet. However, your right not to wear a mask is not a fundamental right. So therefore, the government literally just needs to come up with any reason to have a law that impinges that right. Any rational reason. So we're just going to kind of go through now and kind of see, because there is a lot of talk about how the 10th Amendment applies. And all of a sudden the federal courts are, they're states' rights advocates here on this issue because they don't want the big bad federal government coming in and saying that they can't do lockdowns, which in a way is kind of a libertarian decision, right? So if we kind of dive into it, here's the beginning. I didn't bring any water down with me. Damn it. So plaintiff brings this action on behalf of herself and her minor daughter against defendants Franklin Square Union Free School District, in short, the school district, and the Commissioner of New York State Department of Public Health in her official capacity, alleging that the Commissioner's regulation requiring that New York State's school students wear masks, the mask mandate, violates their constitutional substantive due process rights. So that's referring to the Due Process Clause. Plaintiff has moved for a preliminary injunction, I explained that already, to prohibit defendants from enforcing the mask mandate. That motion is denied as a matter of law based on the party submissions. But plaintiff also has two so they're saying that the plaintiff has state law-based claims that won't be decided in this decision, and they're actually going to send it to the state courts. Every time I click, it switches pages. So the court first kind of laments the fact that, COVID-19 has presented myriad challenges. It's ensnared our children because it's the pandemic that's ensnaring our children and not, the government's reaction to the pandemic. But now that the new school year has begun, the debate rages as to whether they should be required to wear masks while attending school. Our country is being challenged to rationally decide how to best protect the health of our children in uncharted waters that make all of us medical guinea pigs. Sure, it's not, the government and the government policy that's making kids medical guinea pigs. It's COVID. So indeed, there is no conclusive study as to either the short-term or long-term effects that mask wearing could have on children. And you'll see there is so much editorializing by the judge in this opinion, and he actually addresses it at the end, because judges are not supposed to they are supposed to call balls and strike. They are not supposed to go up and opine and be policymakers like Ruth Bader Ginsburg. According to what a judge's job is, it's not to create policy. It's to say what the law is. And as a libertarian, I think that a judge just going up and saying what the law is a pipe dream. We talked about John Hasness and the myth of the rule of law. It's a pipe dream. And the conservative jurists would say, like the Federalist Society, of which I was vice president in law school, of the chapter, my local school chapter. But the Federalist Society would say that a judge's job is to say what the law is, not what it should be. However, we know from John Hasness that that's a pipe dream, because there is no law. There is no objective law. So if there's no objective law and it's all just relative, because that's the nature of the law, then how can a judge go up there and just say what the law is? Because there is no is. But I digress. So for the following reasons, he says, this judge, I'm constrained to deny plaintiff's request for preliminary injunctive relief based on her alleged constitutional violations. However, since the court is sensitive to the concerns that parents have for their children, it believes that a full exploration of the national mask mandate dynamics at play and the reach of the commissioner's actions is warranted, as well as the reasons why the court sua sponte ordered a hearing on the state law claims to determine whether they might separately merit preliminary injunctive relief. So he's an activist judge in this decision, because it says that he thinks, because of the unprecedented time, he can step in and give his own soapbox opinion on what the national the dynamics at play behind the mandates is. So he says the logical starting point is to comprehend the balance struck by our founding fathers between the powers of the federal government and those of the states, which informs us as to which level of government they decided should be responsible for enacting laws affecting our country's health and safety, and the standards that judges must employ in assessing the constitutionality of those laws. So now he's a Michael Bolden. He's a 10th Amendment Center advocate on this issue. And I think, I think it's correct. The police, we'll talk about it in literally a second, but the police powers do reserve to the states the ability to judge on issues of public health. It's not a federal issue. That being said, the individual state constitutions should prescribe the limits of the state in dealing with medical emergencies. Sadly, they don't. A lot of them don't. Or they've been shot to Swiss cheese, just like the federal constitution. So the 10th Amendment and the police power. 10th Amendment reads, we all should know, powers not delegated to the U.S. by the Constitution nor prohibited by it to the states are reserved to the states respectively, or to the people, which I think is the most important line probably in the whole GD thing, to the people. By contrast, unlike those of the federal government, the states' powers do not flow from the Constitution. This is important. The states' powers do not come from the Constitution, and they do not need constitutional authorization to act. That is a recent court ruling, but it's true. Our cases refer to this general power of governing possessed by the states, but not by the federal government, as police powers. The police power has traditionally encompassed the authority to provide for the public health, safety, and morals. Now, that is a recent ruling, so that is just what the court has dictated and made up, based on precedent, but based on made-up precedent. So they kind of look to tradition here to determine what police powers are. This was a 1991 case he's citing, Barnes v. Glenn Theater. But furthermore, he says the protection of public health is one of the historical underpinnings of the police power. So that was another case decided in 1879. So an old case, Stone v. State of Mississippi. That case, quote, said, "No one denies that the police powers extends to all matters affecting the public health or the public morals." And again, citing another case, Mugler v. Kansas, 1887. The police power entitles the legislature to enact measures, quote, "for the protection of the public morals, the public health, or the public safety." So he talks about the landmark slaughterhouse cases, which are progressive era court cases, I believe. But I'm reaching back to law school here. But the Supreme Court noted that the police power incorporates the principle, and this is important. This would come from a progressive era court. The police power incorporates the principle, quote, "that every person ought so to use his property as not to injure his neighbors, and that the private interests must be made subservient to the general interests of the community." Can you think of a more like eviscerating the Constitution and a more kind of Orwellian, like, yeah, we believe in liberty, but kind of statement? So I don't disagree with this, that every person ought so to use his property as not to injure his neighbors. Agreed, right? Okay, this is what I don't agree with. And that private interests must be made subservient to the general interests of the community. Okay, does the community have property rights? Because you started that sentence off really well. Every person ought to use his property as not to injure his neighbors. That's libertarianism 101, right? Well, we're going to take that and warp it into this Orwellian understanding of saying that somehow the community has property. Thus, furthermore, the police power extends to the protection of the lives, health, and property of the citizens and demands the application of the maxim Salus Populi Suprema Lex. And I think I was wrong about the slaughterhouse cases. It appears the citation says 1872, and that was before the progressive era was really going on in full swing. But then he goes to 1905. The Supreme Court applied the police power to vaccine mandates in Jacobson v. Commonwealth of Massachusetts. And I believe I talked about this on the podcast here in some of my cases or my episodes where I kind of tackled this. But Jacobson doesn't necessarily say what everyone thought it said. But they explicitly cited the police power. The court upheld a broad construction of the state's powers to regulate public health and reaffirmed that public health is the domain of the states and their legislatures. So the case didn't say that the federal government can do vaccine mandates. Now, the case did say that a state government has the power to decide whether or not it can do vaccine mandates. However, that being said, the case, the Jacobson case, there was a nominal fine for not getting the vaccine. So if you wanted to pay a fine, not saying that's libertarian or that's just, but if you wanted to pay a fine, you could get out of it. So a matter of public health, clearly. And a Salus Populi Suprema Lex is from Cicero, typically translated as "let the good of the people be the supreme law." So take that as you will. So going back, a matter of public health is, quote, "for the legislative department to determine in light of all the information it had or could obtain." So under our conception of law, the legislature is supposed to represent the will of the people in theory. That's what they're supposed to do. The executive branch executes the laws. The legislative branch is the voice of the people in creating the law, and the judicial branch is the one that checks the other two by making sure the legislature stays within the bounds of the fundamental law, according to our current system and the way it's been interpreted, that the legislature is there to call balls and strikes, essentially. So, consistent with the historical conception of the police power, the Jacobson court noted that at least where the police power is concerned, liberty of the individual is tempered by the common good. And that was, like I said, I think I covered in the Jacobson case that was heavily cited Buck v. Bell in that decision, that the mandatory sterilization case, I think it was a Virginia law, that said that the unfit and should be sterilized. And this was Oliver Wendell Holmes Jr., the eugenicist Supreme Court justice. And that's the dark side of that some states are going to make the wrong decision. But then again, if you have a decision from the federal government, they could make the wrong decision, where Oliver Wendell Holmes Jr. certainly did. But this is the kind of thinking that gets you mandatory sterilization. Liberty of the individual is tempered by the common good. And like I said, every time I click the mouse, it switches pages on me. So the possession and enjoyment of all rights are subject to such reasonable conditions as may be deemed by the governing authority of the country essential to the safety, health, peace, good order, and morals of the community. Even liberty itself, the greatest of all rights, is not unrestricted license to act according to one's own will. It is only freedom from restraint under conditions essential to the equal enjoyment of the same right by others. It is then liberty regulated by law. So this kind of thinking gets you to the reasoning that, people can't just have the liberty to have children when they want to have children, because their children could be degenerate and it would restrict the morals of the community. So therefore, we have to sterilize you. That's what that language means in practice. That's a citation from the Jacobson case, talking about even liberty itself, the greatest of all rights, is not unrestricted license to act according to one's will. So you can't just have kids if you're degenerate, because that will, bring down everyone else in the community. So Jacobson has established a two-part test for judicial review of public health regulations. Such a regulation should only be struck down if, one, it has no real or substantial relation to public health, or two, it is, quote, beyond all question a plain, palpable invasion of rights secured by the fundamental law. So mandatory vaccination apparently is not a palpable invasion of rights secured by the fundamental law. Neither is sterilization or vaccine mandates. But Jacobson predates judicially established tripartite nuanced tiers of review to assess a statute's constitutionality. So remember, I was talking about the different tiers of review that the Supreme Court created: strict scrutiny, intermediate scrutiny, rational basis with a bite. That happened after the Jacobson case. So he's saying that Jacobson, in its time in 1905, established this two-part test to test public health regulations. The regulation should be struck down if it has no real or substantial relation to public health, or if it's beyond all question a plain, palpable invasion of rights secured by the fundamental law. That was replaced by rational basis with a bite, intermediate scrutiny, and strict scrutiny. So he's taking a look at the past, what they've done, and Jacobson is just more on point. But he talks about the applicability. So he says, under those tiers, if the right infringed is fundamental or the law relies upon a suspect classification, strict scrutiny is applied. Under that standard, a law is upheld only if it is narrowly tailored to a compelling state interest. If the law does not infringe upon a fundamental right, but incidentally burdens a First Amendment right or implicates a quasi-suspect classification, such as one predicated on gender, intermediate scrutiny should apply. So this is what I was talking about before. such as gender discrimination, or there's other things. But under that standard, the law must also be narrowly tailored, but must need be, quote, no greater than is essential to the furtherance of an important or substantial governmental interest. So that's intermediate scrutiny, right? In all other cases, every time I click, it switches pages. In all other cases, rational basis review is the standard. Under that standard, the law would be constitutionally flawed only if it was not, quote, rationally related to a legitimate state interest. So that means pretty much everything. Thus, courts are challenged today with the task of harmonizing Jacobson and the test it iterates with the tripartite modern standards of review typically used by courts evaluating constitutional challenges. Further complicating the challenge is some inconsistency in the Supreme Court's substantive due process jurisprudence. In Rokfin v. California, the defendant swallowed morphine capsules during a search, whereupon sheriff deputies took him to a hospital to have his stomach pumped to recover evidence. The Supreme Court held overwhelmingly 8-0 that such conduct violated the due process clause because it shocked the conscience, in quotes. 3 years later, it articulated the modern formulation of rational basis review in Williamson v. Lee Optical of Oklahoma, Inc. Nevertheless, courts have continued to invoke the shocks the conscience standard in substantive due process cases. For example, in Maniscalco v. New York City Department of Education from 2021, Judge Kogan held that mandatory vaccination order for employees of the city's Department of Education was not, quote, so egregious, so outrageous, that it may fairly be said to shock the contemporary conscience. So therefore, in that ruling, the October 15th, 2021 ruling in the Second Circuit, Federal Circuit, the judge ruled that vaccine mandates did not shock the conscience. Therefore, they didn't violate the Supreme Court's substantive due process jurisprudence. So although I guess I'm reviewing this because I want people to be as black-pilled as I am. I guess I don't want you to be black-pilled, but I want you to see what what we have to expect in taking these challenges to court. That's not to say that we shouldn't do it, but we shouldn't put all of our faith, or even the lion's share of our faith, in challenging and striking down these laws. Because I think everyone in the libertarian community should probably know that this is how they're treated. Like, this is the state of our Constitution, essentially. And of course, everyone listening to the podcast should know that I'm not a fan of the Constitution. Lysander Spooner, libertyweekly.net/2 is the episode, my second episode, where I talk about all that stuff. But so although the interplay between the shocks the conscience standard and rational basis review is not clear, it appears that the former is generally reserved for evaluating individual governmental actions not embodied in a statute, regulation, or similarly binding statement of policy. So he's saying that the shocks the conscience standard doesn't apply to the mask mandate. And therefore the substantive due process clause, or that construction of law, doesn't apply to the mask mandates, because the mask mandates are not an individual governmental action. Essentially, the mask mandates are statute. It's not an action by the state that isn't embodied in a statute. It is embodied in a statute. So because it is embodied in a statute, shocks the conscience doesn't apply, the substantive due process standard. But so it's since it's a regulation, he says the court applies the tripartite levels of scrutiny rather than the shocks the conscience standard. So he does say one circuit court has recently applied the more permissive Jacobson standard, because the Jacobson standard, as bad as as bad as the rule, like the ruling in Jacobson wasn't necessarily bad. It doesn't say what people thinks it says, but it's more permissive. And I think it would be bad if this court used the Jacobson standard, because it would be more permissive of the state law. But then again, the libertarian argument that the federal constitution shouldn't shut down and preempt the state laws. But as stated in Abbott, when faced with a society-threatening epidemic, a state may implement emergency measures that curtail constitutional rights so long as the measures have at least some real or substantial relation to the public crisis and are not beyond all question a plain, palpable invasion of rights secured by the fundamental law. So, a lot of the lockdown orders were challenged and won. The challenges won. So I'm not saying that it's completely useless, but this is so permissive that these lockdown and emergency measures at least have to have some real or substantial relation to public health. That's incredibly permissive. However, at least in the context of the free exercise clause, the Supreme Court has rejected Abbott's embrace of Jacobson. So there's some pushback on that notion that I was just deriding. So the Second Circuit has followed suit. And the Second Circuit noted that a reliance on Jacobson is misplaced in the context of a free exercise challenge to COVID restrictions. Have those decisions abrogated Jacobson's relevance in all constitutional cases arising from the pandemic, or can they be cabined to the free exercise context in which their holdings arose? So there's just a little disagreement in the courts about how applicable Jacobson is. That, remember, that the more permissive holdings, the two that predate the strict scrutiny, rational basis, there's some disagreement about the applicability of that. But it doesn't really matter. The continued vitality of the Jacobson test is in flux. However, in the present case, the court concludes that the rational basis review is applicable, that under the standard, the plaintiff's challenge to the mask, that under the rational basis standard, the plaintiff's challenge to the mask mandate's constitutionality is not viable, and that it also fails under the more deferential Jacobson test embraced by Abbott. So he's saying, we don't know what the true state of Jacobson is right now, but it doesn't matter because the plaintiff's challenge fails under Jacobson and it fails under the rational basis. So he's ruled that rational basis doesn't apply. He's ruled that rational basis is the standard that applies and it's not strict scrutiny or even intermediate scrutiny. So you can see some of his reasoning there in trying to parse through this 10th Amendment issue in the Jacobson case, where those two things are, the Jacobson case decided a 10th Amendment issue, and the modern understanding of the 14th Amendment jurisprudence with the rational basis and all those different standards. Now he talks about the mask mandate. He decries how convoluted it is, and it's a mishmash of different regulations. Commissioner's regulations, their implementation, determination, findings of necessity, requirements, and recommendations. It's just a mishmash. And the CDC is in there, the Department of Health interim guidance documents for classroom instruction, guidelines that the education department has promulgated. So it's a complex web of sometimes contradictory regulations put forward by a whole bunch of different agencies. First, and this is maybe the most important part of this entire episode and this entire decision, is this part right here, because it really sets the stage for how every single COVID case is going to go. The Supreme Court has recognized, he says, that courts should generally defer to the, quote, reasonable medical judgments of public health officials. And this is a ruling that was created by School Board of Nassau City, Florida, versus Arline, or Arlene, Arline. This is a 1987 case that ruled that courts should defer to the reasonable medical judgments of public health officials. So therefore, this court says the CDC is obviously the federal agency responsible for protecting the public health of the country by providing leadership and direction in the prevention and control of diseases. Although recognizing that its guidelines are not dispositive, sure, the Seventh Circuit has cogently articulated the significance and importance of the CDC's COVID-19 pandemic determinations. So essentially what you're getting here, and this is, if you take anything away from this episode, is the degree to which the courts defer to public health agencies, creating what amounts to a rebuttable presumption that these public health agencies are accurate and are giving the best information and are not compromised in any way. So the courts are deferring to these agencies. They are creating, well, this infrastructure has already been in place for a long time. As some, like a James Corbett would say, the gears just needed a trip event to set all this in motion, that everything was in place. These public health statutes and the powers, the emergency powers, were given in the last 30 to 40 years. And we have court decisions saying, and precedent directing future courts to defer to public health agencies and give them a rebuttable presumption. And I put out a Twitter poll the other day when I was actually reading and studying this case for the first time, that is this a conflict of interest that you would have a federal court overseeing a case where another, well, this is a state statute that is being challenged here, but that you would have a federal court accepting and assuming as truth what another federal agency like the CDC has said or the FDA has said. Now, people who actually believe in the myth of government or the legitimacy of government would say, oh yeah, this is kind of the same argument as like the "we are the government," right? The Murray Rothbard thing from Anatomy of the State. You can't say we are the government because that just is false, and it's a myth that just allows the government to do anything, because by definition, if we are the government, then the government doing something to us is just us doing it to ourselves, right? Therefore, under that theory, the Jews would have committed suicide because it was the government that genocided them, that perpetrated the Holocaust against them. Well, that's just them committing suicide, because if the government is us, then anything the government does is justified. Well, by that same logic, I would make the argument that people who say this, that, oh, well, the federal judiciary really is not, there's no conflict of interest when the federal judiciary reviews its own actions, or when the federal judiciary rules about something involving the FBI, right? Because the FBI is an administrative agency, or, the name your agency, NSA, I think they do the CISA courts or something else, but, the CDC or the Department of Education, or when the judiciary reviews a law that's been promulgated by the legislature. It's the federal government reviewing the federal government, or the federal government reviewing a federal agency. Well, that's not a conflict of interest, because you see they're different branches, right? They're really different. They're different branches. To me, that's such a myth. It's a conflict of interest, clearly, because of the magic that these branches are separated, they have different prescribed powers and duties, doesn't mean that they're not batting for the same team. And I think it takes a certain level of naivete to actually imbibe that. Hey everyone, and welcome to the portion of the show where I tell you how you can help support this content. Your one-stop shop is libertyweekly.net/support. And once you're there, you can see all the different ways to support my content. There is a Amazon wishlist there you can check out. There's also a PayPal button, paypal.me/libertyweekly for one-time donations. There's also a Patreon button and a Subscribe Star button where you can donate on a monthly basis in exchange for the bonus content that I do offer. So go check those out. There's an archive there with actually hundreds of posts going back years, and you get all access to all those things with your donation. There's also cryptocurrency addresses there with all the addresses for the cryptocurrencies that I accept. If you don't see one there you'd like to donate, just get in touch with me. And if you want access to bonus content, but you don't want to pay a monthly fee, you can go over to Odyssey, libertyweekly.net/Odyssey, ODYSEE, and you can purchase my bonus content there a la carte, and you can purchase it for LBC, which is the cryptocurrency that the website runs on. The best deal for subscribing and getting my premium content, though, is to go to Rokfin.com, Rokfin. You can, for $10 a month, get access to tons of your favorite creators. And you also get access to my premium content there as well. And there's a lot of great creators there that you can check out on the screen here. But for you listening in the audio version, Last American Vagabond, Monica Perez and Brad Binkley from the Propaganda Report, Joanne Leone from Around the Empire, Kyle Anzalone as well from the Libertarian Institute, just a whole bunch of people, Whitney Webb from Unlimited Hangout. So go check that out. One monthly subscription gets you access to all of that. And if you like my writing, I do sometimes release blog posts that don't end up on the Libertarian Institute on my Substack /Substack. So you can go check that out as well and see some of my writings for my email list. And of course, the Liberty Weekly podcast appears on the Libertarian Institute at libertarianinstitute.org, alongside other fine podcasts, Scott Horton, Pete Quinones, Free Man Beyond the Wall, Conflicts of Interest with Kyle Anzalone, Don't Tread on Anyone with Keith Knight, my show, and also Year Zero with Tommy Salmons. So go check out those other fine podcasts and help support the Libertarian Institute, libertarianinstitute.org. Thanks, everybody, and back to the show. So they recognize that the guidelines aren't dispositive, but yet the Seventh Circuit has cogently articulated the significance and importance of the CDC COVID-19 pandemic determinations. Even if not dispositive, and they keep saying that it's not dispositive, but they treat it like it is. Even if not dispositive, implementation and proper execution of guidelines that express an expert agencies' views on best practices are certainly relevant to an objective reasonableness determination. So, right, the reasonableness, the rational basis review requires a rational basis for the statute or the law, right? So, we have it because whatever the CDC says is rational, and we have a rebuttable presumption, what amounts to a rebuttable presumption that it's right. This is particularly true here, where the CDC guidelines provide the authoritative source of guidance on prevention and safety mechanisms for a novel coronavirus in a historic global pandemic where the public health standards are emerging and changing. And that's Mays v. Dart, Seventh Circuit decision. Thus, the CDC has consistently been cited as an acceptable rationale for governmental officials during the pandemic. So this is an objective judge just calling balls and strikes. Actually, he said in the beginning, and he says at the end, that I took judicial license here to educate the public on the real matters at play. So in the midst of a pandemic, it is clearly reasonable for state and local officials to follow the CDC's guidance. This is another ruling, Henry v. DeSantis. So you can see, what that was probably had to do with. This was a Florida decision from 2020. The executive orders explain the governor used scientifically based research policies from the U.S. Centers for Disease Control. There is nothing arbitrary about the governor's actions. Using science, medicine, and data, the governor took reasonable steps clearly related to the legitimate interest in protecting the public. So it sounds to me like this was an approval of what Governor DeSantis did when he first locked Florida down. So, yeah, that Governor DeSantis, the one who actually did lock Florida down, the one that post-libertarians and other libertarians are holding aloft, yeah, he did lock Florida down. And the Florida Supreme Court, if I'm reading this correctly, the Southern District of Florida, it's a federal court reviewing his decision. I need to know more about that. So now I'm looking like an idiot. But this court approved DeSantis's lockdown order. I just don't know which court it is. I think it's a federal court. Henry v. DeSantis. It looks like the Southern District of Florida, so it's a federal district court. So plaintiffs also do not allege facts suggesting that the policy lacked a rational basis. So maybe that's the fault of the plaintiff. Indeed, as the directives were issued in response to rising COVID-19 infection rates and balanced on CDC guidance regarding reopening schools. Defendants' affidavits. These are quotes from other cases that had to deal with mandates and things relating to COVID-19. But defendants' affidavits. This is a different case. Massachusetts, Harrods v. University of Massachusetts, Lowell. Defendants' affidavits attest that the vaccine policy was supported by, among other things, CDC guidance and research that the vaccines were safe and effective. So the underlying regulation, I'm not going to read through all of this, but it was supported by CDC research, which is really important when you have a rebuttable presumption that the CDC is always correct. And it just went through what all the masking orders were. Then the court goes through the guidance from the CDC specifically, saying that, and remember, we're talking about a New York case where a public school student was challenging the New York mask order in school. And so they go through the CDC guidance. Defendants attached to their papers a second CDC masking document. Guidance for wearing masks helps slow the spread of COVID-19. We all heard this before. Nonetheless, in addition to recommending that masks should be worn by people 2 years old or older while in public, the CDC notes that most people with underlying medical conditions can and should wear masks. And if that you have asthma, you can wear a mask. So, however, it recommends that those with asthma discuss with the healthcare provider if they have any concerns about wearing a mask, but they need to wear it, damn it. So, talking more about New York guidance and education department guidelines, going through all the rules that were put in place. So here they discuss other states' approaches to mask mandates and saying that other states fall into one of three buckets. One, states such as New York and Massachusetts require masks at a statewide level. States such as Georgia allow localities, municipalities, or school boards to decide whether or not mask mandates are appropriate. And three, states such as Texas that prohibit mask mandates. So they talk about more about how other states have handled the issue. Hybrid approaches, Texas being Texas. So they're talking more about they go into the facts of what the case is. The specific plaintiff has asthma and cannot medically tolerate wearing a mask is the allegations. So they go through the complaint. They want basically the school didn't allow any exemptions, didn't allow the plaintiff to attend school remotely or do anything like that. So the plaintiff, and this is, again, really important, and I realize I'm going long here because there's so much to this, and I appreciate it if you guys stayed this long. I hope it hasn't been boring so far, but we're getting more to kind of the black pill area. So plaintiff relies upon several studies and government declarations to bolster her argument, to support her contention that there is no scientific evidence that masks are an effective measure against COVID. She points to product labeling requirements and FDA emergency use authorizations for face masks, surgical masks, and respirators. To further that argument, she cites several scientific studies. So, you know that thing on the mask, the box of the mask boxes that says that the masks don't protect against COVID-19? You can understand where, for liability's sake, they would slap that on there, even if they want to say that the masks actually do protect against COVID-19. You can see they're trying to have that disclaimer for liability's sake, not to make a warranty legally. So I don't like this argument, although common sense, it would seem to make sense that the box says doesn't protect against COVID-19. That doesn't necessarily mean the masks don't just by itself. I think people get caught up on that because I can see why the manufacturer wouldn't want to make that warranty that it would be effective for liability's sake. So I don't like that argument, and I don't know if I would submit it to the court, but this attorney did. First, plaintiff points, and so the next section is where the judge in this case just waves away every single study saying that masks don't work with the stupidest reasons. So you'll see plaintiff points to a study comparing cloth and medical mask usage in adult healthcare workers, which concluded that rates of influenza infection were higher in participants who use cloth masks compared to those who use surgical masks. But that study had nothing to do with mask use by children. So he waves that entire study away by saying that the masks had nothing to do with kids, because somehow transmission in children is going to be different than transmission in adults. And it didn't have anything to do with the general public. Indeed, its authors recognize that further research is needed to inform the widespread use of cloth masks globally. Okay, well, we're just going to discount the entire study because it didn't deal with children and it didn't deal with the general public. Instead, it dealt with hospitals where influenza and different diseases and viruses are way more prevalent than in the general public. So I don't get this judge. Like, obviously he's being driven by his own personal feelings here. So he said the study limited its findings to a precaution that cloth masks were not appropriate in the healthcare setting. Next, plaintiff relies on a study published by the CDC itself, the one that he proclaims to have a rebuttable presumption of trustworthiness and authority. The effectiveness of various personal protective measures against influenza, including hand hygiene, respiratory etiquette, and mask usage, right? So that was a CDC study with influenza. The study reported no statistically significant decrease in influenza transmission with the use of masks. So this is a 2020 study by the CDC saying that masks don't work to prevent influenza. He waves this away, however, the judge does, by saying the authors of the study do not represent that face masks in general are inadvisable. Indeed, they note that in theory, transmission should be reduced the most if both infected members and other contacts wear masks, but compliance in uninfected close contacts could be a problem. Okay. So he's saying the study says that masks don't work against influenza, but the judge waves that away by saying the authors don't say that masks don't work against COVID. They just say it doesn't work against influenza. And he says that, God damn it. He says that in theory, the authors say in theory transmission would work. In theory transmission should be reduced the most if both people are wearing masks. And he uses that as some kind of like triumphant point that undercuts the idea that masks don't work against COVID by a statement where they say in theory transmission should be reduced, as if that's authoritative. In addition, he says, the judge, while the authors did not find a statistically significant reduction in influenza transmission with the use of a mask, they nonetheless noted that face masks might be able to reduce the transmission of other infections and therefore have value in an influenza pandemic when healthcare resources are stretched. Okay, that is not authoritative at all. I'm just boggling at that. Like, he's using these slam dunk statements that don't at all support what he thinks. Like, they say face masks might be able to reduce the transmission. That has no backing or bearing on anything. There's no evidence to suggest that. So plaintiff also submits a study published in the New England Journal of Medicine examining COVID-19 transmission in U.S. Marine Corps recruits. That study found that after 2 weeks, 2.8 of recruits strictly observing mitigation measures that included masks tested positive for COVID-19, and 1.7% of those who did not undertake mitigation measures did. But that study tested, so he waves this all away by saying that study tested conditions that are hardly typical for school students The recruits were required to undertake a 2-week home quarantine prior to reporting for duty, and upon reporting undertook a second, strictly supervised quarantine. Indeed, the authors noted that other settings in which young adults congregate are unlikely to reflect similar adherence to measures intended to reduce transmission. So admittedly, that study might not be as effective. But the judge does this thing where if it's not specifically a study that takes place in a school setting with young kids, then it has no bearing on anything. Because, the viruses, I guess apparently mask use and transmission is different based on whether the person wearing a mask is a child or not. I guess the fundamentals are different. I don't know. Maybe I'm the idiot. I don't know. In addition, plaintiff relies on effectiveness of adding a mask recommendation to other public health measures to prevent SARS-CoV-2 infection in Danish mask wearers. This is a study in the Annals of Internal Medicine. That study, however, he waves it away, did not find a statistically significant relationship between mask wearing and lower rates of COVID-19 transmission. However, it only this is how he throws it away. It only examined adults and was undertaken, quote, in a setting where mask wearing was uncommon and was not among other recommended public health measures. The study emphasizes that it did not measure the effect of masking as source control and notes that its findings do not provide data on the effectiveness of widespread mask wearing in the community in reducing SARS-CoV-2. So this is a mixture, I think, of the judge being incredibly obtuse, I think, but it also maybe the only studies that he decided to highlight in his decisions were the ones that he could distinguish. But I mean, to me, I don't think that these would be the studies that I would choose to submit if I were the attorney, because there's better studies out there than this. But you can see how he, in my opinion, unfairly just waves them away. So plaintiff also cites novel risk factors for coronavirus disease-associated mucormycosis, a case control study using an outbreak in India for the proposition that mask usage can cause coronavirus disease-associated mucormycosis, a fungal disease. However, that study, which was undertaken in India, could not obtain information about the frequency of laundering or discarding of masks, which affects fungal growth. It further noted that CAM is strongly associated with diabetes, poor glycemic control, and systemic steroid use. The only scientific material plaintiff cites that deals with mask use in children is a mini-review published in Acta Pediatrica, a peer-reviewed international medical journal. This document notes, however, that there was a, quote, lack of information on the consequences of children wearing face masks, and that, quote, as using face masks could be a long-term preventative measure in the COVID-19 era, further studies are needed, particularly to explore the impact on pre-existing respiratory problems in children and adults. The review also acknowledges that, quote, fake news about the negative effects of face masks have been rising. It has included false reports about face masks causing an increasing number of illnesses and even deaths among children. The review cites to only 2 pediatric studies. The first was of 106 children in Singapore and concluded that masks did not affect a child's heart rate, respiratory rate, or oxygen saturation. The study was of 24 children in the UK. It did not collect physiological data, only subjective information from the children whose main complaint was that their face was hot. So the review also included 8 adult studies, one of which concluded that face masks did not cause any clinically relevant changes in oxygen or carbon dioxide concentration. So the judge concludes, after he went through her papers with, I think, a microscope, and you'll see how he treats the CDC studies that the defendant cites. But most of the studies deal with mask usage by adults in environments very different from that of a school. For example, a high-risk hospital ward or a lockdown and quarantine Marine training camp. The only evidence she musters with respect to mask wearing by children is a, quote, mini review, which acknowledges that there is a lack of information on the consequences of children wearing face masks. And here's where things get really interesting and probably should inform, probably should cast everything that I just read that the judge wrote about the plaintiff's submissions. He says, some of plaintiff's arguments mirror spurious claims publicly aired by one of her attorneys, Robert F. Kennedy Jr., and the organization he founded, Children's Health Defense, which have been criticized for spreading false information about vaccines and the pandemic. For example, in an article misleadingly titled "California is Still Masking Children Despite Proven Physical and Physiological Danger," Children's Health Defense represents that thousands of scientists decry mask use in children, which Children's Health Defense claims causes cognitive fog, depression, despair, detrimental psychological harms, and dehydration, while, quote, lowering children's oxygen levels in the blood, suppressing the immune system, and collecting and colonizing viruses, bacteria, microbes, and mold. Reputable sources have debunked these unfounded claims. So this is an objective judge here who is just calling balls and strikes. For his part, Kennedy has tirelessly... Now, I'm not saying here that there aren't things to criticize about the plaintiff's submissions. Like, don't get me wrong, but I am saying that the judge is not calling balls and strikes, okay? For his part, Kennedy has tirelessly spread a wide variety of pseudoscience. This is the judge, including anti-vaccine propaganda, both during the COVID-19 pandemic and before it, and the myth that 5G cellular phone service causes, quote, almost unimaginably devastating impacts on our health and environment. And by the way, on number 12 here, when he was citing Children's Health Defense, and here he says, so he cites that, but when he says that Children's Health Defense is debunked, I guess he's citing Mayo Clinic. I wanted to see if he was citing like the Washington Post and stuff. Yeah, he cites Vanity Fair here to say that Robert F. Kennedy Jr. is like one of the disinformation dozen. And he cites Twitter. So I wanted to kind of highlight that. Although he does cite to McGill University in Canada, but he cites Vanity Fair. So I don't know. Anyways, although plaintiff paired some of the claims raised by Children's Health Defense, she wisely does not submit them or any of their references to the risks of masking as one of her exhibits. So, yeah. In contrast, now he treats the judge, who is only calling balls and strikes, is now talking about the defendant's submissions. In contrast to the material submitted by plaintiff, defendants embrace the findings and recommendations of the CDC. Their submissions all focus on the reduced spread of COVID-19 in schools with mask mandates. First, defendants submit the abstract of an article examining COVID-19 transmission in North Carolina public schools based on research conducted by the ABC Science Collaborative, a public health organization associated with Duke University. That research concludes that mitigation measures that included masks had lower COVID-19 transmission rates in schools than those school rates in surrounding communities. In addition, the Science Collaborative notes that, quote, most of the cases of secondary transmission were related to absent face coverings. It concluded that, quote, proper masking is the most effective mitigation strategy to prevent secondary transmission in schools when COVID-19 is circulating and when vaccination is unavailable or there is insufficient uptake. So, I mean, with the fact that this judge is calling an attorney that's part of the plaintiff's legal team one of the disinformation dozen and saying that he is propagating pseudoscience, can you trust that the judge is putting a microscope to these CDC studies in the same way that he's putting a microscope to the plaintiff's studies? Now, don't get me wrong. I'm not saying that all of the plaintiff submissions show definitively that masks don't work or anything like that. I'm not saying that. In fact, I would suspect that plaintiff submitted a lot more different studies and that the judge cherry-picked the ones that he could find at fault with. I wouldn't be surprised if that's the case, but it's speculation on my part, right? But I'm just saying that the judge did not go into the defendant's submissions and put a microscope to the CDC studies the same way that he tears apart all the other studies. He doesn't quote anything like he quoted for the plaintiff studies saying, more data is needed to be able to tell this, because almost every study that I've ever read says that more data is needed. We can't say definitively this. But I digress here. So again, I'm not saying the plaintiffs and their claims are the pinnacle of truth or anything like that. Just focusing on how the judge treats these different litigants. It concluded that proper masking is the most effective mitigation strategy because, of course, the CDC is going to say that. Defendants also attach a series of CDC-published morbidity and mortality reports, each authored by groups of physicians, professors, and members of the CDC COVID-19 response team. Those reports examine COVID-19 transmission in schools in Utah, Missouri, Georgia, and Wisconsin. Each report concluded that masks in schools with mitigation measures, including masks, the COVID-19 transmission rate was lower than in the surrounding community. Doesn't talk about their methodology or anything. The judge doesn't. Each study recommended that mask usage, or talk about, the CDC's incentives and who's a part of the CDC, or anything about the credibility of those studies, the way he did with the plaintiff. For example, a CDC study of Utah school reopening concluded that, quote, in-person elementary schools can be opened safely with minimal in-school transmission when critical prevention strategies, including mask use, are implemented. La-di-da-di-da. The Georgia study focused on kindergarten through fifth grade and found that adjusting for county-level incidents, COVID-19 incidence was 37% lower in schools that required teachers and staff members to use masks, but it did not produce a statistically significant result with respect to schools that required mask use among students. The authors concluded that because universal and correct use of masks can reduce SARS-CoV-2 transmission and is a relatively low-cost and easy implemented strategy, findings in this report suggest universal and correct mask use is an important COVID-19 prevention strategy in schools as a part of a multi-component approach. So, I'm boring myself. So I'm probably boring you, because who wants to read any more CDC studies or hear all of the propaganda repeated ad nauseum? But, the judge does not take a critical look at the time periods that are involved, in the same way that if you go into like Tom Wood's COVID mask test or COVID charts quiz, covidchartsquiz.com or whatever it is, try and put a link in the show notes page. If you go into that, the common problem that you have with these studies is that there actually is no correlation, and that they focus on a short period of time that shows what they're saying it shows. So I don't know if the judge, I don't know if this is beyond his role as a judge, but if he wanted to take the study and actually look at it and zoom out the time period and see if it's still true then, or if all of these are just cherry picked, that's quite possible, because that is what's happening and has been shown to happen, not as a part of this podcast, but as a part of what other people have done. I'll put a link in the show notes page to Tom Woods has done a lot of work on this, but that the studies that are cited to, destroy our liberties are ones that are cherry picked like this and where the data is manipulated. But the judge says defendant studies are better tailored to the issue before the court than plaintiffs. Unlike plaintiff submissions, they examine the transmission of the virus in school-aged children and in the school environment. So he just fawns over the defendants and then talks about, the preliminary injunction standard. He says why he thinks that he kind of goes over what the existing law on school mask mandates is. And I'm not going to go through it because it's a whole lot and we're already an hour and 15 minutes in. So he goes through a little bit more, but I wanted to go through and see how he waves away all of the common arguments that you'll hear from people. He waves away the right to a medical exemption. He waves away, let's see. He waves away the right to refuse medical treatment because masks aren't a medical treatment. He waves away a parent's right to make educational decisions. A state cannot, let's see. It should, however, be obvious by now that even fundamental rights are not absolute, he says about a parent's right to dictate, a parent's right to make educational decisions. That even fundamental rights are not absolute. And he cites the Wisconsin v. Yoder case, stressing that there's no support to the contention that parents may replace state educational requirements with their own idiosyncratic views of what knowledge a child needs to be a productive and happy member of society. So a parent's right to dictate what their children learns ends at the schoolhouse doors. That's what they cite here. Because, you couldn't have public schools then. Wouldn't that be terrible? Yeah, no one is forcing plaintiff to send her child to public school or live in New York State, but once she made those decisions, she must comply with their rules. Her authority stops, so to speak, at the schoolhouse door, and for good reason. Like a physician with a patient, a parent may justifiably be expected to act in the child's best interests, but it is that very motivation, laudable in itself, that might lead the parent to misjudge what is best for the health of the community as a whole. Man, like, this language is just totalitarianism at its finest. That is precisely why we as a society have entrusted public institutions to make such decisions. In sum, the court concludes that the mask mandate does not impinge upon any fundamental right. Therefore, strict scrutiny is not the standard by which plaintiffs' constitutional claims must be evaluated, nor do plaintiffs' claims call for intermediate scrutiny. As with the handful of all the other cases that have passed upon the constitutionality of mask mandates, it will evaluate the mandate under rational basis review, noting in passing that it easily passes the more deferential Jacobson test, that it has a real or substantial relation to public health. So I'm going to skip through some of the more nuanced things. Other laws. Yeah, here. So this is what the courts think about your Nuremberg trial, your Nuremberg Code defenses. Plaintiff also contends that the mask mandate is preempted by various federal laws, including Section 564, the Food, Drug, and Cosmetic Act, and the Nuremberg Code. These arguments are without merit. First, Section 564 does not include a private right of action. It confers powers and responsibilities to the Secretary of Health and Human Services in an emergency, not, quote, an opportunity to sue the government. Nor is a private right of action separately supplied by the Supremacy Clause. It is not the source of any federal rights and certainly does not create a cause of action. Citing the Nuremberg Code, plaintiff argues that the mask mandate violates the international norm that one cannot be coerced into a medical experimentation without consent. The mask mandate is not an experiment or clinical trial. It is a school safety measure. So that's what they think of your Nuremberg Code. Recasting it as an unlawful human experiment is an irrational leap of logic. So, I mean, I don't know. I have no faith in international law because I don't think there should be an international law that can step in and supersede national, state sovereignty, basically. State sovereignty or national sovereignty. Furthermore, individual sovereignty. I mean, don't get me wrong. I'm a individualist anarchist, libertarian anarchist, but I mean, there is something to say that earlier at the top, the judge was saying that COVID-19 has made us all into guinea pigs. You do remember that at the beginning of the episode. Now he's saying that making everyone wear masks is not a experiment or a clinical trial. It is a school safety measure. So, and he said earlier that he did say earlier in the opinion that having people wear masks, the effectiveness of having kids wear masks is still in flux. But he's saying now it's a school safety measure. It's not a clinical trial, even though it's kind of the argument like, well, we won't know how effective it is until we do it. So it's not an experiment or a clinical trial. It's a school safety measure. But no one knows the effects of making children wear masks for substantial periods of time. No one has any idea what the effect on their overall health or psychological health or anything like that is. So I don't know how else you would describe that as, except as an experiment. At the same time, I kind of balk at the Nuremberg Code personally. That might piss some people off, but it just, I don't know. The Nuremberg, Legal Man has said on the Quash, his podcast, he's an attorney as well. He said that the Nuremberg trials were show trials, and that there's fundamental issues of due process with the Nuremberg trials. And that's not to say that Nazis are good or that the Holocaust was good or anything before you jump to that conclusion. It's just to say that, I mean, a lot of it is just a propaganda stunt, a publicity stunt. And now we're going to define like our international norms by a treaty that unelected officials, like if a individualist anarchist or a libertarian anarchist was to make the argument that it's impossible for someone to represent me politically, how could I make the argument that U.S. diplomats or even some kind of like a treaty with another nation should have some kind of bearing on how I live, or should have some kind of legal standing that prescribes certain requirements of me? Like, get the fuck out. So, yeah, that's what the courts think of the Nuremberg Code. He just sums it up. It's not an experiment, and casting it that way is an irrational leap of logic. No argument there. So going through, I mean, he goes to more things. But here's his conclusion, and I'm going to wrap up here, but here's what he ends with. This is kind of something that should be decided by the legislature. The mask mandate's going to expire on November 25th, 2021 anyways, and I'm sure it was renewed by now, but the state will have the opportunity to assess the wisdom of transforming its current complex. So he's going to talk, he talked about how he's pissed off that there was no clear policy about masks. That was the only way he really admonished the defendants. But okay, so this is where he really, I think, should be impeached as a judge. The court, of course, recognizes that it is not its province to usurp the function of the legislature, nor to base its decision on its own personal views. Its function is simply to apply the law of the land, which it has endeavored to do. But, and this is a huge but, given the imponderables and the country's divisiveness over the issue of mask mandates for children, the court has decided to veer from the conventional format of the traditional legal opinion, to which it generally subscribes, in order to educate the public about the current state of reputable scientific studies and the various ways our states have addressed the problem. And he cites Richard Posner, who I think was Posner. I just can't remember exactly when Posner was on the court. So essentially what he's saying is Posner, yeah, I think he's more of a progressive anyways. In anyways, he's saying essentially, it's not my role to usurp the function of the legislature or to say what I think on my personal views. But that being said, I decided this based on my own personal views. And I took this opportunity to be a policymaker and to lecture and instruct the country about what the real science is and how we need to trust the experts and not listen to RFK Jr. or anything like that. So anyways, I've really overstayed my welcome here. I went really long on this, on a topic that is very complex, and legal opinions I know can be pretty dry. So if you didn't enjoy that, my apologies. But I really wanted to kind of give you an example of what kind of faith that we should put in legal challenges to the mask mandates, and to give you a real kind of look at what the state of the Constitution is and how the court treats our liberties, especially the federal courts. So I hope it wasn't too much of a black pill, but it's bad. It's really bad. And this is just underscores the need why we need to get rid of, I think we should return to the clear case doctrine, get rid of judicial review as being this supremacist, this judicial supremacy, go back to a situation, it wouldn't be perfect, to where the legislature is the ultimate decision of constitutionality. That's a bit more of the English system. I guess I could have that criticism, but it's bad. I mean, it's just, you can't trust the legislature. You can't trust the judiciary. So I guess I'm not telling you anything you didn't already know. So, all right, libertyweekly.net/202. I got some things cooking. Wanted to talk about maybe next week, talk about Project Bluebeam. I've never talked about aliens on the podcast before, but I wanted to talk about Project Bluebeam and this idea of like a fake alien invasion. And I think it'd be interesting. It'd be speculative, maybe the most conspiracy that I've gone on the podcast, but I think it'll be a lot of fun. And I think it's something that's actually kind of plausible, even though it sounds crazy just off the bat. So, all right, like I said, /202. We'll catch you next time. Peace.